Hello, lovely people, settle in. You're a woman in ancient Rome. It is early morning, and the city is already beginning its noise. Outside your window, someone is calling to someone else in the street below. The smell of bread is drifting up from somewhere close by. The stone floor of your bedroom is cold under your bare feet, and the lamp on the table is still burning from last night, its small flame steady and quiet in the still air of the room. Your husband kissed you when he came home yesterday evening. You remember it, and if you're honest with yourself about it, that kiss had very little to do with affection. He kissed you to smell your breath, to check whether wine had passed your lips during the day. Because in this city, in this world you live in, a woman who drinks wine has done something close to unforgivable, and because a man once beat his wife to death for exactly that. 1 cup, and the people of Rome did not call it a crime. They called it an example. They called it right. That is where we are beginning tonight, with the hand, with the law, with the extraordinary, carefully constructed legal world that surrounded a Roman woman every day of her life, and with what some of those women quietly, methodically did about it. Let's begin. The house you're standing in is probably not large. In a city like Rome, space is money, and money is always uncertain. But it doesn't matter whether your house is grand or modest, whether you have a garden courtyard at the centre or a single room above a shop. What matters is this: everything in it belongs to your husband. The jug by the door, the chair against the wall, the lamp on the table still burning, its small tongue of flame reflected in the dark glaze of the oil. If you are a Roman wife living under the full weight of the law, then the answer to any question beginning with "whose is that?" is always, reliably, the same: his. And so, in a very real and very specific legal sense, are you. This is not a metaphor. This is not the vague cultural assumption that men were in charge, which existed everywhere in the ancient world and needs no particular explanation. What Rome had was something considerably more precise than that. Rome had a legal concept, written down, adjudicated, applied, and passed from one generation of jurists to the next, called Manus. Manus meant hand, your husband's hand. And when you married under Manus, that hand extended over everything you were and everything you had. Your property, your inheritance, your legal identity, your ability to act in the world as an independent person. You were not, under this system, your husband's wife in the way we might mean the word today. You were, legally, something much closer to his daughter. Under Roman law, when a woman entered into a Manus marriage, she became a member of her husband's family in the same legal category as his children, which meant she answered to him the way a child answered to a father, without appeal, without external oversight. The house was his, the law said so, in writing, on bronze. The document that said so was called the 12 Tables. Rome had them drawn up around 450 BC, a set of foundational laws inscribed, according to tradition, on 12 bronze tablets and displayed in the Forum so all citizens could read them, or at least look at them. Literacy was not universal, but the laws were public, and the laws were clear. A woman in a Manus marriage had no independent legal standing. Her assets, if she had any, transferred to her husband upon marriage. Her legal identity dissolved as cleanly as salt in water into his. Sit with that for a moment. Not just the weight of it, but the precision. Rome was extraordinarily good at precision. The Romans built aqueducts that ran for hundreds of miles and arrived level at the other end, which is an engineering achievement that still impresses. They wrote legal codes that governed millions of people across 3 continents, and when they decided that a wife would be legally equivalent to a child, they said so, in writing, on bronze, in the Forum. This was not custom, it was engineering, applied to human beings. Before we go further into this world, because there is a great deal to cover tonight and I want you to be comfortable for all of it, I should tell you that I do read comments, usually well past midnight when I really should have gone to sleep hours ago. Tell me where you are right now and what time it is there. And if this is your kind of thing, a subscribe helps more than you might imagine. Take a breath. The room is still. We're going deeper. The Manus system, the system of the husband's legal hand, did not spring from nowhere. It was connected to something even larger and older, something that shaped every aspect of Roman social and legal life. It was called patria potestas, the power of the father. In Rome, this was remarkable in its scope. The father, the paterfamilias, the male head of the household, had in the earliest periods of Roman law an authority over everyone under his roof that was, by almost any modern standard, total. His wife, his children, his grandchildren, even adult children who had their own homes and their own careers technically remained under their father's potestas until he died or formally released them. A Roman senator in his 40s, commanding legions, debating in the Senate, could still be, in the eyes of the law, subject to his elderly father's legal authority. In the archaic period of Roman history, in those early centuries before the law began to slowly, grudgingly evolve, that authority included the power of life and death. A paterfamilias could, in theory, execute a member of his own household for an offence he judged serious enough. He was, within the walls of his home, judge, jury, and if he felt it necessary, executioner. No court, no trial, no appeal to any outside authority. You might be thinking that this sounds extreme. You're right. Even Romans eventually thought so, though it took several centuries for that feeling to translate into any legal reform. But in the world we're entering tonight, this is the architecture. This is the structure inside which every Roman woman lived, worked, raised children, and made whatever calculations she needed to make. But there was, within this system, a crucial distinction. A woman did not simply move from freedom into subjugation when she married. She moved from one form of subjugation into another. Before marriage, she was under her father's patria potestas. After a Manus marriage, she was under her husband's. The legal authority had transferred, but the category of her existence, legally dependent on a male relative, had not changed. Unless. And here is the first thing about Rome that will surprise you tonight. Unless she engineered it otherwise. The Romans, being Romans, had not one method for establishing Manus, but three. 3 different legal mechanisms, each with its own ritual, its own requirements, and its own consequences. Understanding all 3 is how you begin to understand where the cracks were. The first was called confarreatio. This was the oldest, the most sacred, the most binding form of Roman marriage. It involved a religious ceremony, an offering of spelt bread to Jupiter, witnessed by the Pontifex Maximus, the highest priest in Rome, and by 10 additional Roman citizens. If you married by confarreatio, the manus that resulted was absolute, total, and essentially irrevocable. To dissolve it required an equally elaborate ceremony running in reverse, called defarreatio, with its own priests and its own witnesses. By the time of the late Republic, this form had become so architecturally cumbersome that almost nobody used it except the priests who were legally required, by the rules of their office, to have been born of exactly such a marriage, which, as requirements go, was quite a commitment. The second was called coemptio. This was a symbolic purchase. The groom would perform a formal legal act of buying the bride from her father, a legal fiction understood by everyone present to be exactly that, a fiction, but useful for the formal transfer of patria potestas from father to husband. It was considerably simpler than confariatio, and could be reversed with appropriate legal manoeuvring, which made it more practical for families who wanted flexibility in the future. The third method, and this is the one we will come back to, the one with the buried door inside it, was called usus. This was effectively the common law version of Manus marriage. If a man and woman lived together as husband and wife for one continuous year without interruption, Manus attached automatically. No ceremony, no ritual, no priest, just cohabitation, 12 months, and the law assumed the rest. And buried inside the rules for usus, someone had noticed something. Someone sitting with the 12 tables, working through the logic of the law the way the Romans always did, with methodical, almost architectural attention to consequence, had noticed a very specific, very precise gap. We will get to that gap. But first, there is something else that needs saying. Because so far all we have established is the legal structure, the framework of ownership, and ownership in Rome was never just about property. It was also about what an owner was permitted to do. The lamp on the table is still burning, the city outside is getting louder, and your husband is in the next room. The question is what the law permitted him to do next. But before we answer that, let us stay inside that mourning house a little longer. Because the legal structure is one thing, and what it felt like to inhabit it every day is another. And the feeling matters, because it is the feeling that explains why the law was so persistent, so resistant to reform, and so successfully internalized by the people who lived inside it. A Roman wife of the propertied class in, let us say, the 2nd century BC lived inside an architecture of expectations so total that most of its elements were invisible to her, not because she was unaware, but because they had been there since before she could think. The virtue she was praised for, and praise mattered enormously in Rome, were the virtues of the household, pudicitia, meaning sexual modesty, castitas, meaning chastity, pietas, meaning duty and faithfulness to family and gods, lanifica, meaning skill with wool, the symbolic evidence of domestic industriousness. These were not merely admired, they were the categories through which a Roman woman's value was assessed, discussed, and publicly recognized. A woman who was known for pudicitia was a woman whose reputation could open doors, smooth alliances, and protect her children's futures. A woman who lacked it, or was seen to lack it, found those doors closing. Social standing in Rome was maintained collectively by the family, and a wife who damaged the family's reputation damaged everyone in it. This was not an abstract moral concern. It was material. The marriage alliances available to her sons, the political associations available to her husband, the legal protections available to herself, all of these rested partly on the family's collective good name, and the family's good name rested partly, in ways that were always disproportionate, on her. This is why the internal pressure to conform was so strong. Not because Roman women were passive, not because they lacked the intelligence to see the constraints around them, but because the constraints were woven into the reward system of their entire social world. The woman who embodied the traditional virtues was praised, protected, and publicly honored. The woman who visibly departed from them risked everything, and most people, given that choice, find ways to work within the system rather than against it. You can see this clearly in the Roman practice of publicly commemorating exemplary wives. The laudatio funebris, the funeral speech, was one of the most important rituals of Roman social life. At the funeral of a prominent Roman, a male relative would deliver a speech in the forum praising the deceased's virtues and achievements. For women, the surviving texts of these speeches cluster around a remarkably consistent set of qualities. She was faithful to her husband. She kept the household. She was modest. She was industrious. She raised her children well. The Laudatio Turiae, one of the most complete surviving examples, a funeral speech addressed by a husband to his wife and dating from around 10 BC, is an extraordinary document. It is also, if you read it carefully, a document that describes a woman who saved her husband's life during the political violence of the civil wars, who managed their estates alone for years, who negotiated with armed men on his behalf, and who offered, when they could have no children together, to divorce him so he could find a woman who could give him an heir, which he refused. She was doing all of these remarkable things, and the speech praises her primarily for her pudicitia, her modesty, her domesticity, her wifely virtue. That is the shape of the cage. Not that it prevented extraordinary things from being done inside it, but that it required those extraordinary things to be described in public in the language of the ordinary, of the expected, of the appropriately female. The lamp on the table is still burning, the city outside is getting louder, and your husband is in the next room. The Romans, to their credit, did not leave this as a vague cultural understanding. They thought it through. They codified it. And what they arrived at was a domestic authority so complete that there is almost no equivalent for it in any legal system most people today would recognize. Under the full Manus arrangement, a woman's husband was not just her husband. He was her legal representative before the law, the person who could bring lawsuits on her behalf, sign contracts in her name, and make binding decisions about her property, her children, and her future. She could not initiate legal proceedings independently. She could not appear in court as her own advocate. She could not write a will that Roman law would honour without his active cooperation. In the eyes of the state, she did not quite exist as a separate legal person at all, and yet here is something that is easy to miss if you approach this topic from the outside looking in. A very large number of Roman women accepted this system not as cruelty, but as order, as the natural shape of the world. There's a Latin word for the feeling, pietas, a kind of sincere, practiced faithfulness to one's duties and relationships. A good Roman daughter was pious to her father. A good Roman wife was pious to her husband. This was not considered by most people inside it to be a cage. It was considered the structure that held civilization together. Whether you find that comforting or deeply unsettling probably depends quite a lot on where you're sitting tonight. The physical world of a Roman wife was organized entirely around the household. The domus, even the Latin word for family, familia, originally referred to the entire household unit as a legal and economic entity. The people, the property, the slaves, the obligations, all of it under one man's authority, all of it in the eyes of the law an extension of him. Your mourning, if you are that woman in the early light, might involve supervising the slaves who prepared the food, overseeing the weaving which respectable households still performed even in the late Republic as a mark of domestic virtue, receiving visitors in the atrium, the entrance hall that functioned as the social heart of a Roman home. And here is something that many people do not know. Unlike women in ancient Athens, who were often kept in entirely separate quarters away from the sight of male guests, a Roman wife could be present and visible in the social life of her household. She could host dinners. She could converse with her husband's political allies. She could form her own alliances across the dinner table. All of this she did while being, on paper, legally equivalent to a child. The Romans were very good at holding contradictions without feeling any particular need to resolve them. It was genuinely one of their more remarkable civic skills. The lamp on the table is burned lower now. Its flame is smaller than it was when the morning began, but it has not gone out. In a Roman household you would not let a flame go out carelessly. Fire was precious. Fire was watched. There was a goddess, Vesta, whose entire sacred purpose was tending the fire that stood at the heart of Rome itself. Her flame had to be kept burning. If it went out, the Romans believed, something terrible would follow. The priests would perform rites of purification. The city would hold its breath. We will come back to that flame, and to the women who kept it. But for now, the morning is passing, and there is something we haven't yet said. The laws did not simply describe what a husband owned. The law also had opinions about what he was permitted to do with it. The legal authority a Roman husband held in a Manus marriage covered a wide range. On the ordinary end, he could discipline his wife the way a father disciplined a child, correct her, restrict her movements, limit her social interactions, decide who she saw and who she didn't. On the more serious end, he could convene what Roman law recognized as a domestic tribunal, the Judicium Domesticum, Judicium Domesticum. This was not an informal family argument that happened to have witnesses. The Judicium Domesticum was a recognized legal proceeding, held inside the home, without any involvement from the Roman state. The husband would gather his closest male relatives. He would present his case against his wife. Those men would deliberate, and then they would pronounce. No magistrate was present. No Roman court was involved. The state had, in effect, handed the judgment of a wife's conduct to the very man with the most personal interest in the outcome, which, as justice systems go, had some fairly obvious structural problems. The punishments a domestic tribunal could recommend covered a spectrum. At the milder end, there were restrictions on movement, reduction of household allowances, public censure that damaged a woman's social standing. In the middle was formal repudiation of the marriage. At the most serious end, in the earliest periods of the Republic, there was death. There is no record that domestic tribunals routinely sentenced wives to execution. By the late Republic, killing a wife had become legally complicated and socially scandalous. But the framework existed. It had always existed. And a framework that permits something, even when that something is rarely done, still shapes the world inside it. You were a subject, not a citizen. The judgment of your conduct was not a public matter, it was a domestic one, handled inside the home, by the family, according to the standards of the man who headed it. Your hands are folded in your lap, the weaving sits beside you. Outside, a cart rumbles over the stone street below the window. The lamp on the table, smaller now, continues to burn, and you're thinking about the jug on the shelf across the room, because we have to talk about the wine. But first, a moment inside the domestic tribunal itself, because the Judicium Domesticum is one of those Roman institutions that is easy to read in the abstract and harder to feel in the specific. Let us try to feel it. Imagine the room, a large room probably in a substantial house. Morning light through the windows, the kind of light that in Rome in summer comes in hard and warm from the east. Seated along the walls are the husband's brothers, his uncles, perhaps a cousin or two. Men who know each other, who have shared meals and histories and political alliances. Men who have, all their lives, understood that this is part of what family means in Rome, that the family governs its own. The woman stands or sits before them. She is not represented by anyone. She does not have a lawyer. There is no Roman law that requires her to have one in this setting. There is no Roman law that regulates what questions she may be asked, or how the proceedings should be conducted, or what standard of evidence should be applied. The procedure is entirely internal. The husband sets the terms. The relatives judge by the standards they consider appropriate, and the woman speaks for herself or stays silent, and the outcome is whatever the men in the room decide. The offences that brought women to this tribunal covered a range. Adultery was the most serious and the most politically charged. But the domestic tribunal was not reserved only for grave moral failures. Roman men of the early Republic had used it, or claimed the right to use it, for far more ordinary matters. For a wife who'd been seen speaking to men outside the family without permission, for a wife who had left the house at times her husband considered improper, for a wife who had spent household money without approval, and, in the most vivid and persistent example in Roman moral literature, for a wife who had been found drinking. This is where the wine prohibition becomes something more than a social custom and reveals itself as a mechanism of control. Not merely control of what a woman drank, though it was that. Control of what she did, who she saw, where she went, and what she felt entitled to decide for herself. A woman who drank was, in the Roman moral imagination, a woman who was not where she was supposed to be. Not geographically, internally. A woman who had, even briefly, stepped outside the careful enclosure of Roman female virtue and experienced herself as someone with desires of her own. This is what made the wine prohibition so tenacious. It was not really about wine. It was about the boundary between a woman who was contained within the domestic structure and a woman who might, given the opportunity, make her own choices. And Rome was not comfortable with the second kind. The Romans had a very specific story they told about themselves. It was a story about the old days, the days of the ancestors, when Roman men were stern and Roman women were pure and everything was more orderly than it was now. Romans of the late Republic told this story constantly, the way people in every era tell stories about a better, simpler past that probably never existed quite the way they imagine it. And woven all the way through that story, central to it, was the question of wine. Roman women were not supposed to drink it. This was not a polite social preference expressed at dinner parties. In the earliest period of Roman history, in the centuries before the Republic began its long evolution, it was a prohibition enforced with violence, and the law would not interfere with the man doing the enforcing. The logic behind the prohibition was, if nothing else, direct. Wine removed inhibitions. A woman without inhibitions could not be relied upon to keep a marriage vow. Therefore, wine led to adultery as surely as one step leads to the next on a slope. This reasoning was not considered crude or extreme by those who held it. It was considered self-evident. Cato the Elder, the great moralist of the 2nd century BC, stated it plainly. A husband stood over his wife the way a censor stood over a citizen, with full authority to investigate, judge, and correct. And a woman who drank wine had already begun her moral descent, which says rather more about the Roman male imagination than it says about wine. Now, here is the custom that grew directly from this prohibition, and it is one of the most quietly remarkable small details in all of Roman daily life. When a Roman husband came home, he would kiss his wife, the greeting kiss, the osculum. And while this may have looked, from the outside, like an ordinary expression of domestic warmth, a significant and documented part of its function was to let the husband smell her breath. This was not a private household peculiarity. This was a recognized, widely discussed, socially understood practice. Roman writers recorded it. Roman jurists referenced it. The kiss at the door was, in part, a sobriety check, and everyone involved knew it. You can decide for yourself what you make of that. The woman who failed that check, or whose husband believed she had failed it, had no external recourse, no magistrate to call, no court to appeal to. The law had given him authority over her person. The custom had given him a reason to exercise it. We know this not only in the abstract, we know it in the specific. Because Valerius Maximus, a Roman writer of the 1st century AD, who collected historical anecdotes about Roman virtue and Roman vice, recorded a case. The man's name was Ignatius Messenius. His wife had been drinking wine from the family's storage jars, and Ignatius Messenius beat her to death with a club. Romulus himself, Valerius Maximus noted approvingly, would have considered this judgment just. No prosecution followed. No social censure appears in any source. The incident was preserved not as a warning about a violent man, but as an example of a husband fulfilling his duty. The word Valerius Maximus uses around the incident is the Latin equivalent of righteous, correct, proper. Let that land for a moment. Because what we are looking at here is not simply one man's cruelty, though the cruelty is real and total. What we are looking at is a legal and social system so complete in its architecture that it could absorb an act like that and reflect it back as virtue. It didn't require the law to authorize him explicitly. It required only that the law never bothered to stop him, and it didn't. This is the part of Roman legal history that tends to sit with people, not because violence against women was unique to Rome. It was not. It has never been confined to one civilization or one century, but because Rome was so meticulous, so literate, so proud of its legal precision. And this precision, this extraordinary Roman gift for writing things down and getting them right, had produced a system in which a man could kill his wife for a cup of wine, and the state's response was silence. The actual daily experience of most Roman wives was, almost certainly, considerably more ordinary than the worst the law permitted. Most husbands did not convene tribunals. Most marriages proceeded through the quiet negotiations and accommodations that domestic life in every era has always required, across every culture, in every century. The judicium domesticum was a legal mechanism, not a regular household event. But the power was there, and power that is available even when it is not used bends the space around it. You know it is there. He knows you know it. The shape of the relationship adjusts toward it even in the calm moments, even on an ordinary morning, even when no one is saying anything about wine or judgments or what comes next. The ordinary morning is ordinary precisely because the limits are understood by everyone in the room. And yet Rome was not a static place. Rome changed, slowly, grudgingly, sometimes only in name while leaving the substance unchanged. But it changed. The law evolved. The social norms shifted. And one of the most significant changes that happened over the course of the Republic was a change in the very shape of Roman marriage itself. By the late Republic, something remarkable had happened. The Manus marriage, the marriage that transferred a woman's legal identity to her husband's household, had become uncommon, rare, almost old-fashioned among the urban elite who set the social tone for the rest of Rome. In its place, something different, something that, if you look at it carefully, changes almost everything we thought we knew about what it meant to be a Roman wife. But first, let us stay with the change itself for a moment. Because it is easy to describe the shift from Manus to sine manu marriage as a legal reform, a clean transition from one system to another, and to miss what it actually was. It was not a reform. No one sat down, decided the old system was unjust, and changed it. No Roman jurist or senator stood up and argued that women deserved more legal autonomy, and pushed through legislation to grant it. That is not how the change happened. The change happened because the Manus system was inconvenient. Because as Roman families accumulated wealth, and that wealth became more complicated as inheritance patterns crossed family lines, as the propertied class developed increasingly intricate networks of obligation and alliance. The legal transfer of a daughter's entire existence from her birth family to her husband's became a problem. Not a moral problem, an accounting problem, a property management problem. The sine manu arrangement, which left a daughter technically in her father's family, allowed wealth to stay within family networks in ways that the full Manus transfer complicated. Women's legal independence, in other words, emerged partly as a consequence of elite Roman families protecting their own wealth. The freedom that sine manu gave to women was, to a significant degree, a side effect of decisions that were primarily about something else entirely. And if you find that slightly disappointing, you're in good company. History rarely moves for the reasons we would prefer. This does not make the freedom less real, but it should complicate how we think about it. Rome did not decide that women deserved agency. Rome decided that a particular property arrangement was useful, and women ended up with more agency as a result, which is a very Roman thing to have happened, and a very human one. The most consequential changes are often ones that nobody planned for the reasons they actually happened. By the time of the late Republic, the cultural consequences of this shift had built up over several generations into something that looked, from the outside, like a genuinely transformed world for women of the property class. Women who managed estates, who ran businesses, who initiated divorces, who sat at dinner parties where political strategy was discussed and contributed to those discussions, who engaged tutors for their children and directed the education of the next generation of Rome's leaders. All of this was visible in Roman society. All of it was unremarkable to the people living inside it, and yet the ideology had not caught up with the practice. The speeches that praised women still praised them for pudicitia and lanifica. The moral literature still cited Cato's views on the proper subordination of wives. The law still contained at its foundation the structures that had been there since the 12 Tables. The gap between what Roman women of the propertied class actually did in the late Republic and what the dominant moral discourse said they should be was vast. And that gap was not a sign that the system was failing. It was a sign that the system was in the way of most systems that persist for a long time, holding together pieces that no longer quite fit each other. Your hands are folded. The weaving is beside you. The lamp on the table is burned to its lowest point now. The wick is close to the oil, and the flame is smaller than it has been all day, but it has not gone out. It will not go out tonight. Outside, the city has settled into its own particular quiet, not silence. Rome was never silent at night. The carts that were banned from the streets during daylight hours came out after dark, rattling over the stone with their loads. The voices from the taverns carried. A dog barked somewhere and stopped. The Tiber, 3 streets over if you know the direction, moved on in the dark as it always did, indifferent to the city it had watched for 8 centuries and would watch for many more. You are still awake. The question of the jug, of the wine, of what is permitted and what is not, has been in your mind all day, not because you intend to drink, because the prohibition is always there, just at the edge of awareness, the way all prohibitions are always there, even when you're doing nothing to violate them. The boundary defines the space. And you have been thinking today about the shape of the space you live in. The space is real. The space has walls. But the walls, you have been discovering, are not always where you expected them to be. And some of them, if you look carefully, have doors. But before we get there is one more thing to say about the wine, and about adultery, and about the law that eventually tried to govern both. By the late Republic, the domestic authority of the Judicium Domesticum had already begun to erode under the weight of its own inconsistency. Killing a wife had become, in practice, a scandal rather than an example. But the underlying anxiety about female chastity and male honour had not gone anywhere. It had simply found a new expression. In 18 BC, the Emperor Augustus introduced the Lex Iulia de Adulteris, the law on adultery. This was, depending on how you look at it, either a significant improvement or a significant complication, possibly both at once. The Lex Iulia made adultery a formal crime against the Roman state for the first time in history, no longer a domestic matter to be handled inside the family. Now a matter for the courts. Under the Lex Iulia, a husband who discovered his wife in the act of adultery with a man of lower social standing could kill that man on the spot. He could also kill his wife under certain very specific circumstances in a very specific location within a very specific time window after catching her. The law had opinions about this, and it expressed them in considerable detail. What the Lex Iulia actually did, though, was as interesting as what it permitted. By formalizing the crime, it also constrained the response. A husband could no longer simply decide in private that his wife deserved death. He had to follow the law's prescribed procedure. He had to bring charges within 60 days of discovering the adultery. He had to divorce her first, and if he failed to bring charges, he himself could be prosecuted for procuring. Rome had in effect taken an area of entirely unregulated domestic violence and replaced it with regulated domestic law. This was progress. It was also, in the way that Roman legal reforms tended to be, a progress that contained its own set of new injustices. Here is the part that most people overlook when this topic comes up. The Lex Iulia applied to wives. It also applied to Roman women who were not wives, but who were of respectable social standing. But it did not, in quite the same way, apply to husbands. A Roman husband who slept with a woman who was not his wife faced consequences only under very specific circumstances. If she was a freeborn Roman citizen of good family, it was more complicated. If she was a slave, a freedwoman, a prostitute, or a woman of low social status, it essentially was not adultery at all. It was just a husband exercising options that the law considered more or less ordinary. The word adultery in Rome was about a wife's body, not a husband's. This asymmetry was not accidental, it was structural, and it tells you something precise about what marriage was understood to be in Rome and what purpose a wife served within it. Here is the thing that most history books leave out of this picture, though. Here is the part that genuinely surprised me when I started researching this topic. All of this, the tribunals, the wine prohibition, the asymmetrical adultery law, all of it describes a system that was, by the late Republic, increasingly describing a marriage arrangement that most Roman women of the urban elite class were not actually living inside. Because the Manus marriage, the marriage that created all of this, had been quietly, steadily replaced. And the mechanism of that replacement was written into the 12 tables itself, hidden in plain sight, 3 sentences long. And it went like this. If you live with a man as his wife for 1 continuous year, the manus attaches. The law considers you legally transferred to his family, unless you leave his house for 3 consecutive nights each year, in which case the year resets, the manus never attaches, and you remain legally your own person. 3 nights, that was all. The Romans had a word for this provision. They called it the Trinoctium. the 3-night absence, and it was not an accident of the law. It was not a loophole that someone discovered by squinting at the text from the right angle. It was a deliberate provision, written into the foundational law code of Rome, that gave women a recognized legal mechanism for preventing their husbands from acquiring full legal control over them. Think about what that means. Not the legal mechanics of it. Think about what it means in practice. A woman who knew about the Trinoctium and who chose to use it would leave her husband's house for 3 nights every year as a matter of deliberate legal strategy. She might stay with her parents, with a female relative, with a trusted friend, for 3 nights every year, and those 3 nights would reset the clock, and the Manus would never come. Roman writers refer to this practice as if it were an ordinary feature of Roman domestic life, not a scandal, not a rebellion, an ordinary thing that women of good family did if they chose to maintain their legal independence, and many of them chose to. Let us stay with that for a moment, not the legal mechanics, which we've already established, but the actual experience of doing it. The actual texture of 3 nights away from the house. You would have known, if you were a Roman woman of the propertied class who had thought this through and decided to use it, that there were several things the 3 nights required. They had to be consecutive, they had to be voluntary, they had to be your choice to leave, not his request that you go. And they had to happen every year for the provision to hold. Skip a year, remain in the house for 12 continuous months, and the clock ran again. Miss the window, and what the law had quietly been holding in reserve for you attached. So you planned. You thought about it well in advance of the year's turning. You made arrangements because leaving even for 3 nights required somewhere to go. A family home, if your parents still had one and were living, a sister, a female cousin, a woman friend of sufficient standing that your presence in her house would cause no comment. 3 nights was not long. 3 nights was, to any reasonable observer, a family visit. A festival journey, an ordinary thing that Roman women of your class did regularly and without explanation. But you knew what it was. You knew what it meant in the language the law spoke, and if the woman who received you for those 3 nights was herself the sort of woman who had done the same thing or whose mother had, there was perhaps a kind of understanding between you that never needed to be spoken, a recognition. The city moved around you, the house you had left, with its lamp and its weaving and its particular smell of smoke and olive oil, and the leather sandals your husband left by the door, continued to exist without you for 3 nights. And you continued to exist, which was the point, in a form the law had to acknowledge. On the 4th morning you went back. The house was the same. The lamp was burning or had been relit. Your husband may or may not have noticed that the clock had reset. In the world of the Manus provision, that was not the sort of thing that was typically discussed over the morning meal. But in the archives of Roman legal understanding, in the quiet machinery of the law that kept turning whether anyone was looking or not, something had happened. A year had not passed, the hand had not attached. You were still, by the strict accounting of the 12 tables, your own. The city does not know. The street does not know. The lamp on the table has no opinion about any of this, but the document that will eventually describe what you own, what you can pass on, what your legal identity permits you to do in the world, that document will reflect 3 nights that no one else in the house may have understood the significance of, and you will have done it again next year, and the year after, and as long as you live in this house, in this city, in this life, those 3 nights will be yours to take. The evening air is cool now. You're not in the house with the lamp anymore. You're somewhere else. You're 3 nights away. And the city, the same city, looks entirely different from here. The Trinoctium was, in a sense, the mechanism that unlocked everything that came next. Not because it was used by every woman, or even by most women, but because the habit of using it, the culture of using it, the understood social norm that a woman of good family could do this if she chose, quietly accumulated into something much larger over the span of a few centuries. What accumulated was a new kind of marriage. The Romans called it sine manu, without the hand. A marriage in which the husband's legal authority, the Manus, never attached. A marriage in which a woman remained, legally, a member of her own birth family rather than her husband's, and in which she kept her own legal identity, her own property, and something that the Manus system had made almost unimaginable, her own legal standing before the law. By the 1st century BC, the late Republic, this form of marriage had not only become common, it had become the norm, the Manus marriage, the kind we've been describing all evening, the kind written into the 12 tables and presided over by priests, had become the exception. Something old families might still use in certain ritual contexts. But most Roman marriages of the urban propertied class were sine manu marriages, had been for a generation or more. Most of the Roman women walking through the Forum, supervising their households, attending public events, most of them were not legally under their husband's hand at all. Let that sit for a moment, because here is what sine manu actually meant in practical terms. It meant that when a woman married without manus, she did not transfer legally into her husband's family. She remained, in the eyes of the law, part of her father's family, which meant that the patri potestas, the father's authority, still technically applied to her, but now came from a man who was not her husband, who lived in a different household, and who had far less interest in managing the daily details of her life, and then her father died. When a Roman father died, and most fathers eventually did, the women under his patria potestas became something the Romans had a specific legal term for. They became sui juris, their own legal person, subject to no one's authority, legally independent. A Roman matron whose father had died and who was married without manus was, in the strict eyes of Roman law, under the legal authority of no living man. She could not vote, because no one in Rome could vote without standing in a particular civic category, and women did not hold that category. She could not hold public office or stand for election to the Senate. Those paths were closed formally and completely. But in the sphere of private law, of property and contract and inheritance and wealth, she had a legal personhood that would not exist for married women in most of Western Europe for nearly 2,000 years after her. She could own land, not in her husband's name, in her own. She could inherit from her father and from other relatives, keep what she inherited and pass it on in her own will. She could enter into business arrangements, hold investments, run enterprises. Roman women of the propertied class ran businesses. We have documentation of this, not just implication. We have records of women operating bakeries, fulleries for cloth processing, and brick manufacturers. We have evidence of women managing large agricultural estates during the periods when their husbands were away on military campaigns, which was often. She could also, and this is the part that tends to genuinely surprise people, initiate a divorce, not by petitioning a court, not by waiting for the husband to act. She could simply declare the marriage over, send a message, leave, and the marriage, legally, was ended. The Roman state did not adjudicate divorce. It did not require grounds. It did not require a judge. Either spouse could dissolve the marriage by clear communication of intent, and the law would recognize the result. There was still, technically, a system of male guardianship that applied to women even when they were sui juris. It was called the tutela. In theory, a woman needed her male guardian's formal consent for certain significant legal acts, things like making a will or entering into binding contracts above a certain value, that kind of thing, in theory. In practice, by the late Republic, the tutela had become something close to a formality. A woman who found her guardian obstructive could apply to have him replaced with one who was more cooperative. The state would appoint a new guardian. This new guardian, often someone with no personal connection to the woman or her affairs, had little motivation and often little information with which to obstruct her. His role was ceremonial. His consent was a signature, and she went on doing what she intended to do anyway. The Romans had a phrase that captures this dynamic perfectly. They noted with what we might read as mild amusement or mild exasperation, depending on the source, that the tutela of women had become largely a fiction. The women who wanted their guardian's consent obtained it. The guardians who wanted to resist found themselves replaced. The law said one thing. The practice, after several centuries of evolution, had quietly arrived somewhere else. And then Augustus decided to make the practice into law. In 18 BC, alongside the Lex Iulia de Adulteris, Augustus introduced a piece of legislation that changed the legal status of Roman women in a way that no one seems to talk about very much. He granted a formal legal privilege called the Ius Liberorum, the right of 3 children. Under the Ius Liberorum, a freeborn Roman woman who had borne 3 children was permanently released from the tutelar system entirely. No guardian required, for any legal act, for the rest of her life. She was, in the full legal sense, her own person. For freed women, the threshold was 4 children rather than 3, which is a small distinction that nevertheless says something about exactly what this law was and was not. It was not a declaration of female equality. It was a bargain. Rome needed children. Rome's birth rate among the elite classes had been falling for generations. Rome was worried, and Augustus, who worried about nearly everything and turned most of his worries into legislation, had decided to offer legal freedom in exchange for reproduction, which is a transaction that tells you a great deal about the Roman state's relationship to women's bodies and somewhat less than you might hope about its commitment to their personhood. And yet the result was real. A Roman woman who had borne 3 children, who had a deceased father, who was married without Manus, was legally freer in the sphere of property and contract than a married woman in England would be for almost 1900 years after her. The Married Women's Property Act, which gave English wives the right to own their own property, was passed in 1882. A Roman matron of the 1st century BC had, in certain important respects, already been there. That is not a small thing to sit with. You are still outside. The 3 nights are passing quietly. The house behind you is warm, the lamp visible through the window, the city going about its evening business around you, and you have somewhere to be, somewhere of your own, somewhere that the law now recognizes as yours. Not because anyone gave it to you out of kindness, because you understood the law well enough to use it, and you did. What were you going to do with it? That is the question we have to answer next, because understanding the legal structure, both the cage and the hidden door within it, is only the beginning of this story. The real story is about the women who walked through that door, what they built, what they risked, what was done to them when they were seen to be too independent, too prominent, too unconstrained by the world the law had designed for them. Some of them made history, Most of them made families. A few of them made enemies powerful enough to write the history that came after. But before we meet those women, let us take a moment to feel what this kind of legal independence actually felt like on an ordinary day. Not in theory, in texture. You're a Roman woman of the propertied class in, let us say 60 BC. You are in your early 30s. Your father died 3 years ago. You're married without Manus. You have 2 children. You manage a small estate outside Rome that you inherited from your father, which produces a modest income from the olive trees that grow on its lower slopes. The estate is yours. The income is yours. You have a personal account with a banker in the Subura district of Rome whom you see 3 times a year to review your affairs. He is accustomed to dealing with women. There's nothing unusual about this to either of you. Your husband is a political man. He is in the Senate. He spends a great deal of his time managing his public life, his alliances, his debts, his ambitions. He is pleasant enough company at dinner. You respect each other in the way that people who have shared a household for 11 years and negotiated successfully around each other's needs tend to do. The marriage works. But it works in part because you each have a sphere that is clearly understood to be yours, and you do not much interfere in each other's. The atrium of your house, the entrance hall where visitors are received, is your domain in a practical sense, even if the house is legally his. You oversee who comes in. You manage the household slaves, coordinate the cook and the doorkeeper, and the women who work the wool. You receive the wives of your husband's allies, which is itself a form of political work that everyone understands and no one calls politics. You host dinners at which the conversation covers poetry and philosophy, and obliquely the political situation in the provinces, and you have opinions about all of it, and you express them, and no one in your social world finds this inappropriate. On the morning we're considering, you are going out. You have a small business matter to settle at the forum, a boundary dispute involving the olive estate that has been proceeding slowly through the Roman legal system and requires your formal appearance. You will go with your household steward and 2 slaves. You will be back before the midday meal. In Athens, 3 centuries before your time, a respectable woman might not have left a house at all without causing comment. In Rome, you're barely worth noticing. A woman of your class moving through the forum on her own business is part of the ordinary human traffic of the city. The forum in the morning is loud and crowded and smells of the sea of people passing through it. You navigate it with the ease of someone who's been doing it for years. You know which lawyers are reliable. You know which notaries are trustworthy. You know the banker who will give you a straight account of what you hold and what it's worth. You settle the matter. You're back before the midday heat settles over the city. The olive estate remains yours. This is not a glamorous freedom. It is not the freedom of a Cornelia declining a king's proposal, or Olivia managing the affairs of empire. It is the freedom of a reasonably prosperous woman who knows the law, understands her position within it, and uses that position with the quiet competence of someone for whom it has always been the ordinary state of things. It is the freedom of being a legal person, of being able to walk into a forum and speak for yourself and have the law recognize what you say. For most of history, in most places, most women have not had this. For the women of Rome's propertied class, in the late Republic and the early Empire, it was not a gift or an achievement or a revolution. It was simply Tuesday. The value of understanding this is not to make Rome sound progressive. Rome was not progressive. It was a slave society. It was a patriarchy. It excluded women from formal political power completely and permanently. It enforced female chastity with violence and burial alive. It beat women to death for drinking wine and preserved the story as an example of virtue. All of that is also true. But history is rarely simple, and the Roman legal system's treatment of women in the sphere of private law was, by almost any historical comparison, significantly more generous than what followed it. The fall of the Western Empire in AD 476 did not immediately erase Roman legal traditions, but over the centuries that followed, the legal status of women in Christian Europe declined. The gradual dominance of canon law, with its emphasis on female submission and its theological framework around gender, pushed toward a narrower understanding of women's legal personhood than Roman law had maintained. By the high medieval period, the legal independence that had been ordinary for a Roman matron of 60 BC was, in most of Western Europe, essentially gone, and it would not come fully back for another 800 years. The three knights, the sine manu, the tutellas drift toward irrelevance, the ius liberorum, all of it, the entire slow evolution of Roman marriage law, accumulated in the legal personhood as women who could own, inherit, sue, be sued, divorce, and refuse. And then history moved on, and took most of it with it. There is something in that worth sitting with quietly for a moment. The lamp in the window has steadied again. The evening has deepened into full dark, and somewhere in Rome a woman is counting. 1 night, 2 nights, 3. Let us talk about what she did with her freedom once she had it. Let us talk about property. The Roman dowry had a Latin name, the dues, and if you have heard of it at all, you probably picture it as a payment from the bride's family to the groom's, a transaction that transferred wealth in one direction and a daughter in another, and that was more or less the end of it. That picture is approximately half correct. The dus was a payment. It did flow from the bride's family to the new household. But what happened to it after that, and what it meant for the woman at the centre of the arrangement, is considerably more interesting than the standard account suggests. The dus was capital. That is its fundamental nature, not a gift, not a gesture of goodwill between families, a capital contribution to the new household, intended in the language of Roman law for the onera matrimonii, the burdens of marriage, the costs of maintaining a household, the expenses of children and property and daily life. The husband administered it. In many cases he used it, but it was not simply his. In a Manus marriage, the dus effectively became absorbed into the husband's property, as everything of the wife's did. But in the sine manu marriage that had become the norm by the late Republic, the situation was considerably more nuanced. The dus remained, in legal understanding, the wife's, administered by the husband, yes, used by the household, yes. But at the dissolution of the marriage, whether by death or by divorce, the dus was expected to return to the wife directly, if she was sui juris, to her family if she was not. Either way it came back. This meant that a Roman woman going through a divorce, something that could be accomplished, as we have noted, without a court, without a judge, and without any particular bureaucratic procedure, came out the other side of that divorce with her dowry returned, her property intact, and in the case of a sine manu wife, whatever property she had accumulated through inheritance or her own enterprise in addition to that. Elite Roman women divorced and remarried multiple times. This is not an exaggeration for effect. The historical record contains women who went through 3, 4, sometimes more marriages over the course of their lives, each time negotiating the return of property, each time entering a new arrangement. Cicero, that prolific letter writer whose correspondence has survived in extraordinary volume, divorced his wife Terentia after 30 years of marriage. He then married a young woman who was reportedly very wealthy and considerably younger than himself. The young woman divorced him relatively quickly. These things happened, and they were unremarkable. The social stigma attached to divorce in Rome was mild and short-lived, far milder than it would be in most of Christian Europe for the next 15 centuries. For a woman of the propertied class in a sine manu marriage, with a deceased father and at least 3 children, the legal picture looks something like this. She owns land in her own name. She has an inheritance that belongs to her and that she can pass on in her own will. She can initiate a divorce and retrieve her dowry. She can run businesses, manage estates, enter into contracts. She needs no man's permission for any of this, because the tutela has become ceremonial and replaceable. She is, in the private sphere of Roman law, a legal person. Now hold that picture in your mind for a moment, and then consider this. The Married Women's Property Act, the piece of legislation that gave married women in England and Wales the right to own and control their own property, was passed in 1882. Before that act, a woman's property passed automatically to her husband upon marriage. She could not own it. She could not control it. She could not dispose of it, not control it. She could not dispose of it without his consent. This was the law in England in 1881. It had been the law for centuries. It was the law that covered Jane Austen's characters, the Bennet sisters, the heroines of Victorian novels who were at the mercy of whoever married them, and it persisted until 1882. A Roman matron of the 1st century BC had, in certain important and specific respects, more formal legal property rights than a married woman in Victorian England. Not because Rome was progressive, not because Rome believed in female equality, but because the Roman legal system had evolved through its own internal mechanics and contradictions into a place where property law and female legal status had landed somewhere that most of the Western world would not reach again for nearly 2 millennia. This is genuinely strange to contemplate. It is one of those historical facts that sounds wrong when you first hear it, and then sounds more and more right the longer you examine it. And it says something important not just about Rome, but about the relationship between formal law and the lives actually lived inside it. Law does not move in straight lines. It moves sideways. It doubles back. It creates spaces and closes them. It opens doors that no one expected, and locks others that were standing wide open. The Roman women of the late Republic understood this, perhaps better than most, because they had been watching the law move for generations. They had watched the Manus system calcify into irrelevance. They had watched the tutela become an administrative fiction. They had watched the Liberorum turn their bodies into a bargaining chip, and then use the chip to buy something real. They were not passive inside this system. They were observers. They were strategists. They were women who had read the terrain and moved across it accordingly. Your property is yours. Your house, which is also his house, sits in the same street. The lamp burns in the same window. But the document in the chest, the one that names you as the owner of the land in Campania, that has only one name on it, and the name is yours. You have been thinking about what it means to have that document, and you have been thinking about the women who had documents of their own, and did extraordinary things with them. Women whose names the history books still carry. Women whose names the history books dropped. Women who moved through Rome with money and intention, and the particular quiet authority of someone who knows exactly what the law says and is using every word of it. Let us stay with that document for a little longer. Because the property question, as straightforward as it sounds in the abstract, had a texture in daily life that is worth understanding. Roman property law for women was not a theoretical freedom that sat unused. it was exercised actively in ways that show up in the historical record, in legal cases, in business documents, in inscriptions that have survived on stone and tile and lead pipe. We have archaeological evidence of Roman women owning and operating brick kilns. Brickmaking in ancient Rome was big business. The city was expanding constantly, consuming materials at an enormous rate, and the kilns that supplied that construction were, in a number of documented cases, owned by women. We know this because Roman bricks were often stamped with the name of their manufacturer, and some of those names are female. Domitia Lucilla, the grandmother of the Emperor Marcus Aurelius, ran large clay tile operations that supplied the building industry of Imperial Rome. The business was hers, the profits were hers, the decisions were hers. This was not unusual enough to be remarkable. That is the point. It was documented precisely because it was unremarkable enough to be part of the ordinary commercial fabric of Roman life. Women also appear in the Roman record as moneylenders, as landlords, as managers of agricultural estates during the extended absences of husbands on military campaigns, which in the later Republic and early Empire could last years. A wife left managing the family estates while her husband served in Spain, or Syria or Judea, was not an exception to the rule. She was the rule. She was the person who kept the farm running, negotiated with tenants, paid the wages, and made the decisions. And in a sine manu arrangement, what she decided, not on her husband's behalf, as herself, now, divorce and children. This is where the legal picture becomes more complicated, and where the gap between formal law and lived reality becomes harder to read. Roman law on child custody after divorce is one of the areas where the scholarship still debates the details. But the broad picture is this: children of a Roman marriage belonged legally to the father. They were members of his family, his line, his household. In a divorce, they typically remained with him. For a Roman woman divorcing her husband, this was the true cost, not the property, which came back, not the social standing, which recovered. The children stayed. There were exceptions. There were arrangements. Roman families made private agreements about custody that the law did not always dictate. And there is evidence that mothers remained involved in their children's lives after divorce in ways that were socially expected even when not legally required. But the formal legal position was clear. The children belonged to the paternal line. This is not a small thing to understand. It is arguably the most significant constraint on the freedom that the sine manu system and the tutela reforms were offering Roman women of the propertied class. You could own property, you could divorce, you could refuse a king, but your children were his. And if the marriage ended, the daily reality of their lives, their upbringing, their futures, would be shaped by the household he kept and the woman he might eventually bring into it. Roman mothers navigated this with the tools available to them. Cornelia, as we'll see, navigated it brilliantly. Others navigated it through negotiation, through remaining on good terms with former husbands, through the social networks of elite Roman life that kept extended family in constant contact regardless of formal marital arrangements. And others simply lived with the loss, as quietly as everything else in their lives that was not considered worth recording. There is one more woman we should mention before we move into the stories of individuals, because she is, in many ways, the culmination of everything the Roman legal system's evolution had been building toward. She combined all of it: the sine manu arrangement, the ius liberorum, the property rights, the legal independence, and added to it a position at the centre of Roman imperial power that no woman had occupied before. Her name was Livia. Livia Drusilla was born in 58 BC, which put her in her early 20s when she became the wife of Octavian, the man who would become the Emperor Augustus. She'd been married before to a man named Tiberius Claudius Nero. She had 2 sons with him, one of whom, Tiberius, would eventually become Augustus's successor and Rome's second emperor. The details of how her first marriage ended and her second began are part of the complicated political history of the late Republic's collapse, and we don't need all of them tonight. What matters is what her life with Augustus looked like. Livia and Augustus were married for more than 50 years. They had no children together, which under the ordinary rules of the Ius Liberorum would have left Livia under the technical guardianship of the tutela system. Augustus solved this through a formal decree of the Senate. He had the Senate grant Livia the Ius Liberorum by special exception, acknowledging her existing children from her first marriage as sufficient to satisfy the requirement. It was an extraordinary use of imperial authority. It was also, in the context of Rome's legal evolution, a logical next step. The result was a woman who was legally independent in every formal sense, who managed vast personal estates and wealth in her own right, whose portrait appeared on Roman coins across the empire, who was consulted by foreign dignitaries, and whose patronage was sought by senators and artists and cities. When Augustus died in AD 14, his will acknowledged her influence with a formal bequest and an honorary title. He renamed her Iulia Augusta. She was eventually deified by her grandson the Emperor Claudius, who gave her the title Diva Augusta, Divine Augusta, and established formal cult worship in her honor. She lived to be 87 years old. By the standards of any era, that is a remarkable span, and she spent most of it at the center of the most powerful household in the Roman world, managing her own affairs, directing her own considerable fortune, and shaping, insofar as anyone can be said to have shaped events from within a household rather than from a formal political office, the direction of Roman imperial policy in ways that historians are still working to fully understand. Her independence was not symbolic. It was structural. It came from the same legal architecture we have been describing all evening, the sine manu system, the Ius Liberorum, the tutela's erosion, all of it arriving in her case at a woman who used every piece of it. Your property is yours. Your house, which is also his house, sits in the same street. The lamp burns in the same window, but the document in the chest, the one that names you as the owner of the land in Campania that has only one name on it. And the name is yours. We're going to meet one of them now, one of the most celebrated women in the history of the Republic. And we are going to look at what she built and what it cost her and what it means that we still know her name. She was called Cornelia, and her jewels were not what you might expect. Before we meet her, we need to understand who the average Roman woman was in this story. The one we've been imagining all evening. The woman with the lamp and the weaving and the 3 nights of counted absence. Because Cornelia was not an average Roman woman. She was exceptional in ways that mattered. And if we don't say that clearly, we risk doing what history tends to do with powerful women, collapsing the distance between them and the rest, making it seem as though the freedoms Cornelia enjoyed were simply available to everyone who wanted them, which they were not. Most Roman women of the property class had some access to some of the legal mechanisms we've been discussing. The sine manu marriage, the ability to own property under the right circumstances, the possibility of divorce without catastrophic social consequence. These were real, and they were not nothing. But access to those mechanisms depended heavily on birth, on wealth, on whose family you came from, and what resources they had, and how well educated you were in the legal realities of your situation. A woman from a poorer family, a freed woman, a woman of no particular social standing, experienced a very different Rome than the one we have been describing. Cornelia was born into the highest stratum of that Rome. Her father was Publius Cornelius Scipio Africanus, the general who defeated Hannibal, the man whose victory at the Battle of Zama in 202 BC ended the Second Punic War and established Rome as the dominant power in the Western Mediterranean. Scipio Africanus was, in his own lifetime and for centuries after, one of the most celebrated Romans who ever lived. Cornelia was his daughter, and she was educated like one. She married Tiberius Sempronius Gracchus, a distinguished Roman politician and general, older than herself by a significant margin. They had 12 children. Most died young, as Roman children frequently did. 3 survived to adulthood, a daughter and 2 sons, Tiberius and Gaius Gracchus, who would become the most controversial politicians of the late Republic, and whose careers would end in violent death. But we are not there yet. In the years when Cornelia's story matters most to us tonight, the boys are still growing up, and Cornelia is a widow. Tiberius Sempronius Gracchus died in 154 BC, leaving Cornelia to manage the household, the estates, and the education of their surviving children. This she did with considerable care and by all accounts considerable skill. She was known as a woman of exceptional learning. She wrote letters, or at least letters attributed to her have survived in fragments, which makes her one of the very few Roman women whose written words we can read in any form. She hosted scholars and philosophers in her home. Greek intellectuals who came to Rome in this period, and many did, noted her as a woman of genuine intellectual distinction. And then someone asked her to marry again. The man in question was Ptolemy VIII Physcon, king of Egypt. This was not a small offer, this was a king. An alliance with the Ptolemaic dynasty would have been politically significant, personally elevating, and financially comfortable beyond any ordinary measure. Most widows in Roman society, presented with a proposal of this magnitude from a figure of this importance, would have had a very good reason to accept. Cornelia declined. The sources differ on exactly what she said, but the version that has come down to us through history, the one that Roman writers cited and recited for centuries, amounts to this: she had her children. They were her jewels. What would she do with a crown? It is a wonderful line. It is possibly too wonderful to be entirely accurate, which is something you should know about Roman historical anecdotes in general. They had a tendency to become more quotable over time, but the underlying fact is documented and confirmed. Cornelia refused the proposal, remained a widow, and devoted herself to the education and political development of her 2 sons. And in doing so she made a choice that the law now permitted her to make. As a widow sui juris with her own estates and her own household, she needed no one's permission to refuse a king. She raised Tiberius and Gaius to be reformers, to push for land redistribution, to challenge the power of the Senate on behalf of the Roman poor. Both sons died for it, Tiberius killed by a mob in 133 BC, Gaius taking his own life in 121 BC. The Republic was never quite the same after them, and Cornelia outlived them both, living until around 115 BC, and was said to have spoken of her sons without breaking, talking about them as though they were still alive in the good they had intended. After her death, the people of Rome did something they had not done for many women before her. They gave her a bronze statue. It stood in a public place in Rome. The pedestal on which it stood, inscribed with the words Cornelia, Mother of the Gracchi, survives to this day in the Capitoline museums in Rome. You can look it up. The stone is still there. The inscription is still legible. She is still, in some sense, still there. But here is the part of Cornelia's story that stays with me most. She's known to us because men wrote about her, because her sons were famous, because her father was legendary, because the things she did intersected with the political world that Roman men considered worth recording. She had the extraordinary good fortune, if you can call it that, of being adjacent to power in ways that made her impossible to ignore. How many Cornelias were there who were ignored? How many women made the same choices, exercised the same strategic intelligence, refused the same kinds of offers with the same quiet authority, and left behind nothing? No statue, no inscription, no letters, no record of any kind. The historical archive is not a neutral account of what happened. It is a record of what men considered worth writing down, and for most of Rome's history the inner lives and legal strategies of ordinary women did not make that list. What we have is the exception. Cornelia was exceptional. The rule, for most women, was silence. Not the silence of absence, not the silence of women who had nothing to say. The silence of women who said a great deal, made consequential decisions, shaped families and communities and the texture of daily life, and were simply not written about by anyone whose writing survived. That silence is part of the story too, but the silence is not complete. Because Cornelia left fragments, letters, or what scholars believe were letters, attributed to her have survived in the manuscripts of later Roman writers. Two fragments in particular, written in Latin of a style and period consistent with the late 2nd century BC, purport to be from letters Cornelia wrote to her son Gaius, trying to dissuade him from the course of political action that she knew would put him in danger. The authenticity of these fragments has been debated by scholars for centuries. Some believe they are genuine, others argue they are later compositions attributed to her to add moral weight to a historical narrative. The debate has not been fully resolved. But here is what the fragments say, in their substance, regardless of their ultimate origin. They show a woman engaging with political strategy at a sophisticated level. They show a mother arguing with her son not from sentiment alone, but from practical political analysis. They show someone who understood Rome, its power structures, its dangers and its limits, and who was attempting to communicate that understanding to the person she loved most in a way that might actually change what he did. Whether or not those specific words are hers, the capacity they describe is entirely consistent with everything else we know about Cornelia. She was literate in an era when widespread literacy was not guaranteed even among the wealthy. She was educated in Greek as well as Latin, which was the mark of genuine intellectual ambition in her class and time. She maintained a household that attracted philosophers and scholars who spoke with her as an intellectual equal. Plutarch, writing more than 2 centuries after her death, described her as a woman whose good sense was evident in her conversation. Good sense. In Plutarch's world, that was not a small compliment for a woman. The education she provided for her sons is also part of her story. Tiberius and Gaius Gracchus were educated by the standards of their time extraordinarily well. Greek philosophers came to their household. Rhetoric, philosophy, and law were all part of their formation. Cornelia supervised this, as Roman elite mothers typically supervised their children's education, not as a passive observer, but as the person making the decisions about who taught them, what they studied, and what values were communicated alongside the formal curriculum. The Gracchi grew up to be effective speakers, principled reformers, and ultimately men who died for their convictions. Whether those convictions were shaped significantly by their mother is something no historical source can establish with precision. But the Roman tradition, the tradition that Plutarch drew from and that other ancient writers repeated, credited Cornelia with a formative role in producing what the Gracchi were. Rome believed that she had made them, and Rome was not in the habit of giving women credit for things they had not done. After both sons died, Cornelia retired to her estate at Misenum on the Bay of Naples. She received visitors there. Greek scholars and intellectuals came to talk with her, Plutarch says, and she spoke of her sons without tears, narrating their lives as if she were talking about great men of an earlier age who had nothing to do with her. Ancient writers found this remarkable enough to record. A woman who had outlived 2 sons, who had watched them both killed by the violence of Roman politics, and who spoke of them without weeping, describing instead their public achievements as though she were a historian rather than a mother. We cannot know what was actually in her when she spoke those words. The Roman ideal of stoic endurance was powerful and real, and Cornelia had been shaped by it all her life. But there is something in that picture, a woman sitting in a house on the Bay of Naples in her 80s, speaking clearly about her dead sons to foreign scholars who came specifically to hear her. That is both profoundly Roman and profoundly human. The grief was there. She was too educated not to know where it was. She simply chose, as she had chosen everything in her life, on her own terms. The street outside is quiet now. The hour is late. The bronze statue stands in the dark, the inscription still legible after 2,000 years, and the women it does not represent stretch further than we can count. But the silence was not the end, not even close. But Rome was not always silent about its women. Sometimes it was very loud indeed. Sometimes the silence broke open in a courtroom, in the middle of a trial, when a man with a vocabulary like a scalpel stood up and decided that the most effective way to win his case was to destroy the woman who was testifying. That man was Cicero, and the woman was Clodia. And what happened between them in 56 BC is one of the most extraordinary moments in the history of Roman public life. Clodia Metelli was born around 94 BC into one of the most powerful aristocratic families in Rome, the Claudii Metelli. Her full name, for the purposes of Roman naming conventions, identified her as the wife of Quintus Caecilius Metellus Sala. She's usually referred to simply as Clodia, or Clodia Metelli, to distinguish her from her sisters, who were also called Clodia, because Roman naming conventions for women were not known for their creativity. She was wealthy. She was educated. She moved in the highest social circles of the late Republic, a period of Rome's history that was politically turbulent, socially experimental, and filled with powerful people doing interesting and often destructive things. Her husband, Metellus Sala, was a consul and a senior political figure. They were by all appearances a substantial Roman family. Metellus Sala died in 59 BC. The circumstances were, to put it delicately, disputed. He had been ill. He died relatively suddenly. And rumours began almost immediately that Clodia had poisoned him. Let us be careful here, because this is exactly the kind of historical moment where care is required. The rumour that Clodia poisoned her husband is not a documented fact. It is a rumour. It was circulated, it was repeated, it was used against her with devastating effect. But there is no evidence, independent of the people who had reasons to destroy her reputation, that it was true. Historians today treat it as almost certainly a fabrication, or at the very least an accusation without substantiation. What we know is that her husband died, that rumours followed, and that those rumours would later be weaponized. After her husband's death, Clodia appears in the historical record as a widow of independent means, navigating the social world of Rome on her own terms. She had money. She had standing. She had, as a widow whose father had presumably died, and who was living under a sin manu arrangement, the legal status of someone who could make her own decisions. She entertained. She formed social alliances. She had a love affair with a young politician and orator named Marcus Caelius Rufus. The love affair did not end well. Affairs of this kind, in the political environment of the late Republic, rarely did. In 56 BC, Marcus Caelius Rufus was put on trial. The charges against him were multiple and complicated, as Roman legal charges tended to be, but one of them involved an alleged attempt to poison Clodia herself, using a group of her own slaves to do it. The prosecution's theory was that Caelius had obtained poison from another source and had given it to Clodia's slaves to administer to her, either to silence her or as an act of revenge after the end of their affair. Cicero was hired to defend Caelius. What Cicero did in that courtroom is one of the most precisely calculated character assassinations in the entire history of rhetoric, and it was aimed entirely at Clodia. His argument was not subtle. His argument was that Clodia was a woman of such moral corruption, such notorious licentiousness, such brazen disregard for the conventions of Roman female virtue, that her testimony could not be trusted. Her account of events could not be believed, and her role in the case was not that of victim, but of scheming, dangerous, sexually voracious aggressor. He called her, in one of the speech's most famous passages, a Medea of the Palatine, after the mythological figure who murdered her own children. The comparison was not meant kindly. He deployed the rumour about her husband's death, not as a proven fact, as a whisper. An insinuation dropped into the speech in exactly the way that insinuations are most effective, mentioned briefly, denied as too terrible to dwell on, and left in the air for the jury to breathe. He described her social life as evidence of moral disorder. He described her independence as evidence of impropriety. He described her relationship with Caelius as evidence of everything he was claiming about her character, while simultaneously using that same relationship as the foundation of his argument that Caelius could not have wanted to harm her. The jury acquitted Marcus Caelius Rufus. Clodia disappears from the historical record shortly after the trial. We don't know what happened to her. We don't know how she spent the rest of her life. We don't know when she died. She was perhaps 50 when the trial took place. She may have lived another 20 years after it, or 10, or 5. We do not know, because after Cicero was done with her, no one wrote about her anymore. Everything we know about Clodia Metelli comes through men who are either her enemies or her lovers. Cicero, who wanted to destroy her, wrote about her in court. Marcus Caelius Rufus, who had been her lover, and whom she had, in some version of events, accused of trying to kill her, presumably had things to say that have not survived. And then there is Catullus. Catullus was a poet. He wrote in the lyric tradition, short personal poems of extraordinary verbal intensity, love poems and hate poems, and poems that were often both at the same time. And scholars for centuries have believed that the woman he called Lesbia in his poems was Clodia, not proven, not confessed by Catullus himself. But the dates align, the social world aligns, and the intensity of the poems, the way they oscillate between adoration and fury with no stable position in between, suggests a real woman behind the name. If Catullus was writing about Clodia, then she inspired some of the greatest love poetry in the Latin language. Odiat amo, he wrote. I hate and I love. I don't know why, but I feel it, and I am torn. It is 16 words in Latin. It has been translated hundreds of times. It is still, after 2,000 years, one of the most precise descriptions of a particular kind of emotional experience that has ever been written. And the woman at the centre of it left no words of her own. That absence is worth sitting with for a moment longer than we usually do, because the absence of Clodia's words is not just a historical accident, a matter of manuscripts lost or libraries burned. It is structural. Roman women of her class were educated. Many of them could read and write. Some of them wrote letters, kept records, composed what might generously be called literary documents. We know this because the fragments of a few have survived, attributed to Cornelia, referenced by later writers who had seen others. The written word was not impossible for women of Clodia's world. What was impossible was the public word, the performative, audible, officially recorded word, the kind of word that became part of the Roman legal and literary tradition because it was spoken in a forum or published in a form that copies spread through the libraries and education systems of the empire. That kind of word required access to the public rhetorical space, and that access was not available. Cicero could write a speech, deliver it in the forum in front of hundreds of people, have it copied and distributed in its written form, and watch it circulate for decades through the network of educated Romans who read and discussed and copied literary texts. He could say what he wanted about Clodia in that speech, in that public form with that reach, and there was nothing she could do in kind. Whatever she thought of the accusations, whatever account she might have given of herself, and of the events he described, that account would have circulated only in the private, informal, vanishing medium of conversation and personal correspondence, and conversation vanishes. And personal correspondence, unless someone decides it is important enough to preserve, vanishes too. So she remains in the historical record what Cicero said she was, and what Catullus felt she was, defined by the most powerful voice in Rome that chose to speak about her, and by the most emotionally intense voice in Latin lyric poetry, and by no other voice at all. There is something in that which goes beyond Clodia's individual story, because it is the same pattern that governs most of what we know about women in the ancient world. The women we know are the women who were written about by men. The more powerful the men, and the more vivid their prose, the more present those women are in history. Clodia is present in history because Cicero was extraordinary. She is present in a form she could not have chosen and could not contest. She's present as a function of someone else's talent and someone else's need, and that is not quite the same as being present at all. The room is quiet now. The forum is empty. The night has come down over the city, and the only light is the lamp on the table, and the only sound is the sound of the Tiber, moving in the dark the way it always has. Nothing Clodia wrote, if she wrote anything at all, has survived. Everything we know about her is filtered through the hostile testimony of her enemies and the passionate, ambivalent poetry of a man who may or may not have been writing about her. The woman who inspired the Procalio and possibly inspired Odietamo is present in history only as seen by others, only through the lenses that others chose to hold up to her. And those lenses were not kind. Here is what I find worth sitting with in Clodia's story. The legal system had evolved, by her time, in ways that gave her real independence. She was wealthy, she was widowed, she was sui juris. She moved through the world on her own terms, formed her own alliances, made her own choices. The law, or at least its evolution, had provided some of the architecture for that. And then she encountered what the law could not protect her from. Not another Manus, not a domestic tribunal, not the cudgel. Something more durable and more damaging. A voice. a powerful, skilled, weaponized voice that stood up in a public forum and defined her on terms she could not contest, in language she could not match because Roman women could not argue their own cases in Roman courts, and left an account of her that has outlasted everything else. The law could give her freedom. It could not give her credit, and it could not, in the end, protect her from being known only as someone else's story. There is something worth pausing on in the very mechanism of what happened to Clodia in that courtroom. Cicero did not accuse her of anything that could be formally tried. He was defending Caelius, not prosecuting Clodia. Technically, she had no formal standing as a defendant in the pro Caelio at all. She was a witness. And yet Cicero spent a significant portion of one of the longest speeches of his career essentially putting her on trial in absentia, in front of an audience that had no power to convict her of anything and every interest in being entertained. This is a distinctive feature of Roman rhetorical culture that tells you something important about the limits of even the most robust legal independence. Roman public oratory was a performance art. The forum was a stage. A speech like the pro Caelio was not simply a legal argument. It was theatre, and the audience came to it the way an audience comes to theatre, expecting spectacle, wit, the pleasures of a skilled performer commanding the room. Cicero was, by general consensus of people who study rhetoric across all of history, among the finest practitioners who has ever lived. His vocabulary was extraordinary, his sense of timing was precise, and when he decided to use those gifts to describe a woman, he could produce something that lodged in the memory of everyone who heard it and was read, copied and discussed for decades afterward. Clodia had no equivalent platform. Roman women could not argue cases in the forum. They could not deliver public speeches. They could appear before judges in certain narrow legal capacities. But the public rhetorical space, the space where Rome's political and legal life was actually performed and contested and decided, that space was not available to her. Cicero could stand up and describe her in any terms he chose, and her options for response were severely limited. She could speak privately. She could write letters, if she did, though none have survived. She could rely on friends and allies to speak on her behalf in informal settings. She could, if the social world was willing to receive it, maintain her dignity through the way she continued to live her life, but she could not stand up in the forum and answer, and Cicero knew it. Cicero. Here is what I find worth noting. The speech worked. Caelius was acquitted. The jury believed Cicero's characterization of Clodia enough, or found it sufficiently useful, to return the verdict he wanted. And the characterization stuck. 2,000 years later, when scholars discuss Clodia Metelli, Cicero's portrait is still the first thing that comes up, the Medea of the Palatine, the woman whose testimony could not be trusted. Not because any of this was proven, because it was said, brilliantly in public, by one of the greatest speakers in the history of the Latin language, and Catullus. We should return to Catullus for a moment, because he complicates the picture in a way that is, perhaps, more interesting than Cicero's prosecution. If the scholarly consensus is right that Clodia was Lesbia, then we're looking at a woman who was, simultaneously, the subject of Cicero's most devastating legal performance, and the inspiration for one of the most celebrated love poetry sequences in the Latin literary tradition. Both texts have survived. Both are studied, both are taught, and in neither one does the woman herself speak. Catullus writes about Lesbia as a woman of magnetic, dangerous attraction. He writes about her with adoration, and with rage, and with something in between that he cannot name but cannot escape. The poems are intimate in a way that Roman public literature rarely is. They feel, reading them today, like something that should have been private, should not have survived the years and the copying and the eventual printing and the library shelves, and yet they did. So Clodia, if she was Lesbia, is present in history in two forms: as a monster, in Cicero, as a mystery in Catullus. In neither form does she speak for herself. In neither form can you quite see her clearly. You see Cicero's need to destroy her. You see Catullus's need to love and hate her simultaneously. What you cannot see quite is her. The night is very quiet now. Outside, if you're listening, there is almost nothing. The city at this hour reduces itself to small sounds. A door, a footstep, the particular silence that falls between one moment and the next. And somewhere in Rome, in one of these rooms, in one of these lives, a woman is tending a flame. Not because she was told to, because it is her office, her title, her sacred function, because she was chosen for it before she was old enough to understand what it meant, and because in a city full of rules about what women could and could not do, what women could and could not own, what women could and could not say, the Vestal virgins occupied a category entirely their own. There were, at any given time, 6 of them. 6 women serving as the priestesses of Vesta, goddess of the hearth and home, guardians of the sacred flame that burned in the round temple in the Forum that the Romans called the Iades Vesti. The flame was old. No one knew how old exactly. It had been burning, the Romans believed, since the founding of the city, and as long as it burned, Rome would stand. The selection process for a Vestal began when a girl was between 6 and 10 years old. The Pontifex Maximus, the high priest who oversaw the state religion, would identify candidates from prominent Roman families. The girl had to be freeborn, had to have both parents still living, had to have no physical or speech impairment of any kind. She had to be, in the assessment of the priests and the state, suitable. When one was chosen, she was taken. That was the legal term, the taking, the captio. And from the moment of the captio, something extraordinary happened to her legal status. She was freed from patria potestas. Immediately and completely, the father's authority which governed every other Roman daughter until her father died or she married with Manus, dissolved at the moment of selection. She became, in the instant of being chosen, legally independent of any male authority. She was not transferred to a husband's manus. She was not placed under any man's guardianship. She was sui juris from the first day, a legal person in her own right, answerable to the state and to the requirements of her religious office, but to no individual man. Think about what that means for a girl of 7. 7 years old, and already, legally, freer than most Roman women would ever be. She could own property in her own name. She could make a will and have it honoured by Roman law without a guardian's signature. She could appear in court and give testimony that was accepted without an oath, because a Vestal's word was considered by Roman law to be beyond reproach. Her testimony did not require the formal backing that other witnesses required. She was believed by definition. She had a lictor to be precise, an official attendant who walked before her in the street carrying the fasces, the bundle of rods that signified civic authority. The lictor was not a personal servant. The lictor was a mark of office, the same mark of office that accompanied senior Roman magistrates. A Vestal walking through the Forum was accorded the same visible dignity as a consul. If a condemned prisoner happened to cross her path on the way to his execution, she could pardon him on the spot, simply by being there, simply by being encountered. The pardon was hers to give, legally and immediately, without petition, without approval from any court. People stepped aside for her in the street. This was not courtesy. It was law. Anyone who impeded a Vestal's movement, who failed to give way, who showed disrespect in her presence, could face serious consequences. She moved through Rome with a kind of sanctified right of way that no other woman and very few men possessed. Her home was the Atrium Vesti, the house of the Vestals, a large and prestigious complex in the heart of the Forum, directly adjacent to the temple she served. By the standards of Roman housing, it was substantial. Multiple rooms, a garden, staff, a stipend from the state. She lived, in material terms, comfortably. Her service lasted 30 years, 10 years as a novice, learning the rituals and the requirements of the office, 10 years in full practice, performing the rites that were required of her, 10 years as a senior Vestal, teaching the newer members of the order what she knew, 30 years in total, from a childhood she had not chosen into a middle age she had perhaps made entirely her own. After 30 years she was free to leave, free to marry if she chose, which the law permitted and which most Vestals apparently declined. These sources suggest that few did. One account from Plutarch notes that Vestals who left the order to marry tended to have unhappy marriages. Whether this was because a woman who had spent 30 years in complete legal independence found the adjustment to ordinary Roman wifely status difficult, or whether it was simply the Romans reading misfortune into choices they found unusual, is a question no one can answer with certainty. But it is easy to imagine that having been, for 30 years, a person of extraordinary legal status, owning property, commanding respect in the street, giving testimony that courts accepted without oath, you might find the ordinary arrangements of Roman domestic life somewhat constrained by comparison. Now, the vow of chastity. This is the part of the Vestal story that tends to dominate popular accounts. The celibacy, the flames, the burial alive. And those things were real. The vow was absolute, and the Romans enforced it with a ferocity that expressed everything they believed about the sacred nature of the office. A Vestal who broke her vow of chastity was not executed in the ordinary Roman sense. She was buried alive. The Romans did not shed consecrated blood. So they enclosed her in a small underground chamber near the city gate, gave her a little food and water and a lamp, and sealed the entrance. And then they walked away. This happened, not often. The historical record documents relatively few cases, but it happened, and it was considered just, and the man involved was flogged to death in public. Rome took these things seriously in proportion to what it believed was at stake. If the Vestal's purity failed, Rome believed the flame might fail, and if the flame went out, Rome would fall. The city held its breath when a Vestal was accused. The city exhaled when she was acquitted, and the rare occasions when she was not acquitted were treated as a catastrophe that required the entire apparatus of state religion to absorb and repair. The flame itself was the oldest hearth fire in Rome, kept burning in the round temple that was itself built in the ancient style, before rectangular temples with columns became the standard form. There was something deliberate about that architecture, something that said, this building is older than Roman fashion. This flame is older than Roman memory. We do not know when it was lit. We only know it must not go out. On the 1st of March each year, the flame was ritually extinguished and then relighted. A new fire for a new year, kindled from flint and steel in the ancient way, not from another flame, from the spark, from nothing. Every year the fire began again, and every year the Vestals were there, 6 women, in a city of perhaps 1 million people, holding the most complete legal independence that Roman law ever granted to women. More property rights than most wives, more civic authority than almost any woman in the Western world would possess for the next 2,000 years. All of it resting on the condition that they remain celibate and keep a fire burning. There is something in that arrangement that captures the whole story of Roman women's legal history in miniature. The freedom was real. The freedom was also conditional. It came attached to a requirement, a demand, a price. Cornelia's independence came from widowhood and her son's fame. The sine manu wife's independence came from her father's death and her guardian's compliance. The Ius Liberorum woman's independence came from the children her body had produced, and the Vestal's independence came from 30 years of celibacy and a daily obligation to a flame. Nothing was given freely, everything had a cost. But the independence itself, in each case, was genuinely there, not metaphorical, not symbolic, legal, documented, enforceable, real. The flame burns, steady and low and warm, the way it has burned all evening since the lamp on the table in that early morning room, since the first sentence of this story. It is still here. Let us think about what it meant to be one of those 6 women. Not in the abstract, in the specific experience of a life. You were chosen at 7, or 8, or 9. The Pontifex Maximus came, or sent word, and your father was told that his daughter had been selected. The captio ceremony took your hand, and from that moment you were no longer his. You were Rome's. The transition was total. You left your family's home. You moved into the Atrium Vestae, the Vestal house in the Forum, which was large and comfortable and nothing like any home you'd known. You would live there for 30 years. You would sleep there, eat there, perform the sacred rites of your office from there. The women around you were your sisters in the order, older than you, who would teach you what the role required. The routines of the sacred fire, the rituals of the calendar, the precise words of the prayers, the way to carry yourself when you walk through the Forum with the lictor preceding you. You would grow up inside that role. Childhood, adolescence, your 20s, your 30s, your early 40s, all of them inside the office, all of them in the same house by the same flame, performing the same rites in the same sequence through the same turning year. You would watch novices arrive who were younger than you had been when you came, and you would teach them what you'd been taught, and they would grow up beside you, and some of them would still be there when you left. The sacred duties themselves were numerous and precise. The Vestals maintained not just the eternal flame, but also the sacred storerooms of the temple, which held objects considered vital to Rome's safety and divine favour. The Palladium, a statue of Athena said to have been brought from Troy by Aeneas himself, was in their keeping. So were a number of other sacred items whose exact nature was known only to the Vestals, and whose loss was considered catastrophic. They had custody of the wills of prominent Romans, including, at various points, the wills of Julius Caesar and Augustus. No institution in Rome was considered more trustworthy for this purpose. During the major festivals of the Roman calendar, the Vestals played a central role. They prepared the mola salsa, the sacred salt cake used in many of Rome's most important ritual offerings. They attended the major state sacrifices. They were present at events that shaped the religious life of the city in ways that no other women in Rome could be. Their presence at a ceremony was itself significant. Their absence was noticed. Their participation was not ceremonial in the decorative sense. It was functional. The rite required them. And through all of this they tended the flame. The flame was not tended carelessly. It required attention. It was a living thing in the Roman understanding, not merely a symbol but a presence with its own demands. It had to be fed, it had to be watched. Through the night, in rotation, the Vestals maintained the vigil. If a Vestal on watch allowed the flame to dim or die through inattention, the consequences were serious. The Pontifex Maximus could order her flogged. The flame would be relighted by the ancient method of friction. The rubbing of dry wood and the rites of purification would be performed. The city would not relax until the fire was restored. This was not superstition in the way we might dismiss the word. It was a technology of meaning. Rome used the eternal flame as a way of saying continuously, publicly, maintained by real human effort every single hour. We are still here. This city endures. The compact with the gods is kept. 6 women through every night of every year kept that statement alive. After 30 years of this, a Vestal was free to go. And most did not marry. Most of them apparently continued to live in or near the Atrium Vesti, received the honours they had always been accorded, and spent the rest of their lives in the world that had been their world since childhood, which was a world of legal independence, public respect, civic authority, and the daily rhythm of a sacred office that had structured every hour of their adult lives. It is hard to know what they felt about the 30 years behind them when they emerged. There are no memoirs, there are no Vestal testimonials, there are no accounts written in their own words. What we have, again, is the record of what the men around them observed and considered worth preserving, which was mostly the legal framework, the ritual requirements, and the scandals. Not the interior life, but the interior life was there. Behind every Vestal who walked through the forum with her lictor, behind every woman who tended the fire through the cold hours before dawn, was a person who had been 7 years old once and had been taken from everything she knew and had built her entire existence, her sense of self, her understanding of her place in the world inside this extraordinary and demanding office. And the flame they tended outlasted them all. It was extinguished by the Emperor Theodosius in AD 394, when he banned the pagan religions of Rome and ordered the sacred fire put out. The Vestal College was dissolved. The women were released from their oaths. The Atrium Vesti fell silent, and the flame, which had burned for more than 1,000 years by any plausible account, went out for the last time. Rome fell within a century, exactly as the Romans had always feared it would if the flame were lost. Whether you believe in the causal connection or not, there is something in the timing that makes you pause, and perhaps that is the right place to pause, right here, at the edge of that thought. Because we have been moving through a great deal of information tonight, through centuries and laws and lives, and sometimes the most useful thing you can do with all of it is let it settle. What this story is, at its core, is a story about systems, about the gap between what a system says it is and what it actually does, about the way power structures contain their own erosions, their own internal contradictions that accumulate quietly over generations until they produce outcomes no one planned. Rome built a legal cage for its women, and then Rome's own logic, its property laws and family structures and practical necessities, quietly opened doors in the walls of that cage. Not because anyone decided to, because systems are not as coherent as they appear from the outside, because the people inside them are always finding the 3 nights. You have been learning tonight about women who did exactly that, who read the walls and found the doors, who lived, in the most complete sense available to them, inside the space that the system allowed and sometimes slightly beyond it. Cornelia in her house on the Bay of Naples speaking of her sons without breaking. Clodia in the social world of the late Republic, exercising the independence the law had given her, until Cicero's voice took it away. the Vestal in the Atrium Vestae, tending a flame that was older than anyone's memory and more important than almost anyone understood. You've been spending time with them tonight, and now the night has gotten very late. The room you are in right now is quiet, not the noise of the Roman streets, not the carts and the voices and the Tiber in the dark. Your room, tonight, the particular quality of quiet that belongs to the late hour, when the world has mostly gone to sleep and the sounds that remain are small and far away and almost reassuring in their smallness. You can feel the weight of the surface beneath you, the bed, the chair, whatever is holding you right now. It is solid, it is warm, it has been there this whole time, patient and unhurried, while you travelled back 2,000 years and spent the evening in Rome. You are back now, still here, the same room, the same quiet. Let your shoulders drop. If there was any tension there, let it release. You've been carrying a lot of history tonight, and history is heavy, and you don't need to carry it into sleep. Let it rest on the floor beside you. It will still be there in the morning. It has waited 2,000 years. It can wait until morning. The breath finds its own pace. You don't have to think about it. You don't have to guide it. It knows what to do. In and out, slower than you might expect, slower than the pace of learning and absorbing and following a story. The breath of someone who is beginning to rest. Think for a moment of the flame. Not the great sacred flame of Vesta, the one the 6 women tended through the centuries, something smaller. The lamp on the table in that morning room, the one that was burning when we began. It has been burning all evening, through every story, through every woman's name, through every moment of this long and quiet night. Its flame is small and steady and warm. It gives just enough light. The flame, small and steady, warm. You don't have to do anything with that image. Just let it be there, the way a lamp is just there in a room giving its quiet light without asking anything of you. The flame, still here. Your body is heavy now, the pleasant heaviness of a mind that has been somewhere interesting and is ready to come home, the weight of the blanket, the warmth of the room, the small sounds of the late night, whatever they are where you are, the familiar ones, the ones your sleeping self already knows how to ignore. The flame, steady, low. Somewhere in Rome 2,000 years ago a woman was awake. She was watching the fire so it would not go out. She was counting 3 nights in her head. She was dictating a letter to a son she loved and feared for. She was walking through the forum in the early morning with her sicta, the fasces preceding her, people stepping out of her way. She was sitting in a house she owned on the Bay of Naples, speaking clearly about the dead. And now she is resting. They all are, the whole long story of them, resting in the way that everything eventually rests, held in the dark, held in the record, held in the strange warm fact that we are still here thinking about them, 2,000 years later, in the quiet of a night they never imagined. The flame, still here, still warm. You're warm too. The room is the right temperature. The weight of everything is exactly right. Let your eyes close if they haven't already. The flame on the table, small, steady. Someone tended it through the night. Someone always did. Rest now.